Well, good evening, everybody, and welcome. First, I would like to thank CMES for allowing me to present my defense. I would also like to thank the American Institute for Maghreb Studies, or AIMS, for providing me with a grant to conduct part of my research in Morocco. I'd like to thank my dissertation committee for their patience throughout the process of this project. My dissertation is a little lengthy, so what I would like to do is focus on Morocco, which is about 2 chapters. I will try to summarize it within half an hour. But before I do that, I would like to give a summary of the first 2 chapters in order for us to understand the issue. So the first chapter is basically a background on Islamic jurisprudence on marriage. I explored the opinions of Sunni schools of law, the Juris of Sunni schools of law. Also from the Shia schools of law, I explored the opinions of the 12er Shia, as well as some independent jurists. And I found out that although there are certain consensus within each school of law, there are certain independent jurists that did not agree with these rulings. And these minority opinions became important later on, and these minority jurists were from the 8th century that are still, until today, this is 21st century, and they are important till today, and they're quoted quite a bit within the Islamic law. The second chapter is concerning the debates of Arab intellectuals after the codification of the Arab states. When they started, after gaining their independence, Arab states started codifying Islamic family law into what came to be known as the personal status law for each state. When that happened, we started seeing dynamic and vibrant debate among intellectuals throughout the Arab states. Moroccan intellectuals would communicate with Egyptians, Egyptians would communicate with Syrians, Syrians would communicate with Iraqi intellectuals, and so on. So it was across the boundaries. And these personal status laws that were codified, mostly in most states, were based on Islamic jurisprudence, based on the opinions of jurists within the Islamic schools of law, the 4 Sunni schools of law, the Hanafi, the Shafi'i, the Maliki, and the Hanbalis, and from the Shi'as in Lebanon, for example, Iraq, they were based on 12er Shi'i jurists. However, some of them were based on minority opinions, minority jurist opinions. And the 3rd and the 4th chapter are basically on debates within Morocco, and I will start with Morocco, focusing on 2 aspects of the marriage contract. The first one is the legal minimum age of marriage, codifying that, and then the role of the marriage guardian, or the wali, and specifically the male wali, because that's really what is important and what the contention, the point of contention is the male wali, in contracting his female ward, or if the father is the wali or the marriage guardian, then in contracting his daughter in marriage. And by the way, the adult man after the minimum age of marriage is not required to have a male wali within Islamic jurisprudence. Only some cases it is only required, may be required, and there is certain opinions who don't require that for the women. So our focus is going to be on the legal age of marriage for women, and also the marriage guardian for women. And my argument is of 2 folds. First, I argue that the minority opinions of early Muslim jurists, along with the opinions of a few intellectuals, were paramount in influencing reforms among Arab Muslim states that enhanced women's rights according to Islamic family law. The second part of my argument is I argue that conservative intellectual Arab Muslim men are capable of producing liberal work and shifting the discussion over gender rights in Islamic family law. And I will bring an individual that I met in my trip to Morocco and interviewed, who will actually be paramount, and he was paramount in establishing and in the personal status law in Morocco. He participated in the actual making of the family law in Morocco. So unlike other states, Arab states, Moroccan personal law was named the Mudawwana, and from now on I'll refer to it as the Mudawwana. In 1956, Morocco gained its independence from France, and immediately after that, in 1957, the King of Morocco, back then Mohammed V, commissioned a committee to establish a new personal status law for Morocco. The committee was made of 10 individuals. All of them were men with experts, or their expertise were in Islamic jurisprudence, particularly. All the 10 men were experts in Maliki law, and they were all affiliated with one university, which is a conservative, one of the conservative universities in Morocco, which is called Al-Qarawiyyin University in city of Fez. One of the individuals who was really important for us, or was important at the time, his name was Allal al-Fasi. And Allal al-Fasi was not only a jurist, but he was a politician. He was a leading politician in the independent party, or Al-Istiqlal party. He established it. He was prominent in the resistance movement as well. Prior to 1957, Allal al-Fasi, although he was conservative, wrote a book criticizing the customs of Morocco for restricting the freedom of women, and proposed, in 1949, he proposed a minimum age of marriage, and wrote against coercion or early marriage. He also proposed that a woman be educated and become independent. However, after investigating the role of Allal al-Fasi in the Mudawwana in 1957 Mudawwana, he had to give in, because the other 9 jurists wanted the Mudawwana to parallel the Maliki law, and therefore, although the Maliki law does not, none of the school of law stipulate a legal minimum age of marriage, and they go by puberty usually. And they had a legal minimum age of marriage at the time, 18 for men and 15 for women, providing the judge with a broad authority to marry minor girls who were less than 15 years old, and according to his discretion. In terms of the marriage guardian, they required a marriage guardian for a woman who is below the age of 21. 21 was called the age of competency, legal, financial competency. And although the woman is 15 years old, for example, from 15 years old until 21, she is required a male guardian. Above 21, if she is married without a male guardian, the husband has to be from her same social status, or otherwise the marriage guardian has the right to dissolve the marriage. He has the right to petition the court to dissolve the marriage. Of course, upon the publication of the Mudawwana, there was quite a bit of opposition. Intellectual men and women alike opposed what the committee came up with, and many of them saw that it was an insult to women, that a woman needs a marriage guardian at this time. This was the 20th century, and they all asked, why didn't we follow another school of law, which is the Hanafi? And the Hanafi school of law allows a woman Abu Hanifa was one among the minority jurists who allowed a woman to contract her marriage without a marriage guardian, without the consent of a marriage guardian, of course providing that the future husband is of same social status. In 1983, in the mid-80s on, we started having NGOs funded by the West. And these also sided by many of the women and men who wanted to give Moroccan Muslim women broader rights in their marriage and also in their divorce, because the divorce was a unilateral right of the man as well as his right for marrying more than one woman. So among the individuals that came and sided with women as well was Ahmad al-Khamlishi. The opposition to the Mudawwana and the call for reforms escalated until 1992, when the king then, Hassan II, he approved another committee. And in 1993, another committee was established to make the first reform for the Mudawwana. This time, instead of 10, we have 20 men. 20 men. Among them is an individual that is very important, is Ahmad al-Khamlishi. And although the women and NGOs expected certain reforms that they called for, because King Hassan II listened to them and invited them to his palace, but hardly anything changed from the first Mudawwana. Hardly anything changed. One of the changes, just to state them, was lowering the age of competency from 21 to 20. So a woman still has to have a marriage guardian, and the age of marriage, the minimum age of marriage stayed the same. In 1999, and the government, actually a minister in the government from the Socialist Party, made a proposal. He proposed what the government later on sponsored, a government's National Plan of Action, or NPA. And this national plan calls for raising the legal minimum age of marriage for women, eliminating the role of the marriage guardian, restricting polygyny, and restricting the man's unilateral right to divorce his wife, and bringing that any decision of divorce has to go to the court and the judge has to decide on that. While the NGOs and many of the women and a few of the men applauded the plan, there was a mounting opposition from Islamist organizations. One of the Islamist organizations championed a rally, the Justice and Development Party, in 2000, championed a rally in city of Casablanca and rounded almost 1 million individuals against any reforms in the 1993 Mudawwana, calling that any reform is un-Islamic and an assault on Islamic Moroccan society. On the other hand, the NGOs, funded by the West, and also many of the intellectuals and many of the activists in Morocco, had another rally in Rabat. And the discussion, and there was heated debates throughout the media, and the king, the current king, King Mohammed V, the sixth, had to interfere. And in 2001, he announced the establishment of another committee. This committee was unlike the other two committees. It was a committee made of 15 individuals, including 3 women. For the first time, actually this is the first time in the history probably of Arab Muslim states that we have women that are not jurists, a physician. One of the women was a physician. Another one was a social scientist, and then one who was a professor actually at the School of Law in Rabat. So 3 of them had no background in Islamic jurisprudence, but they were expert in their fields. Ahmad al-Khamliji also is expert in secular law aside from Islamic jurisprudence, and he was one of them. And this committee, according to Ahmad al-Khamliji, has quite a bit of tension, as you might imagine. One of the writers actually described the committee of split into 2. 11 jurists with the opposition headed by Ahmad al-Khamliji heading the women, making a dichotomy there. And Ahmad al-Khamliji told me in an interview that the majority, when they used to write the draft, they have written some of the drafts over 4 times. The committee took 28 months to reform the Mudawwana. There was so much disagreement among them that the head of committee had to resign, or was actually deposed by the king, and he had to bring a politician in order for them to agree on something. And Ahmad al-Khamliji said that the opinion of the 11 jurists has to always be in the body of the form or the paper or the draft. His opinion and the opinion of the women were on the margin. Talking about marginalizing the minority. But it was preserved. They wanted, or they insisted on having the opinions of al-Khamliji. So what happened then was something that was not familiar to the 11th jurists on many of the Islamists. The minimum age of marriage was raised for women from 15 to 18. The age of competency now became 18 as well. The judge now is assisted by legal experts and medical experts. If the judge, someone wanted to marry a woman, wanted to marry below the age of 18, she had to go through a process of examinations from a medical expert as well as a social expert. They have to testify and sign along with the woman and her father in front of legal witnesses, 2 legal witnesses, that she is fit mentally and physically to marry if she was below the age of 18. The role of the marriage guardian was almost eliminated and left for the woman. The marriage guardian, if the woman wants the marriage guardian to sign, then the marriage guardian may sign. Otherwise, the woman who reached the age of 18 may conduct her marriage without the permission of her marriage guardian. And in my visit to Morocco, I had the chance to interview 9 intellectuals. I'm going to present a few of them, the opinion of these individuals and their arguments regarding the legal minimum age of marriage, whether they agree with it, the 18 years old for a woman to marry, and whether they agree or disagree with the requirement of the marriage guardian. The individuals I'm going to present, they're all conservative individuals in terms of their upbringing, in terms of their education, and what they teach, except for one, they were all professors. The first individual, unfortunately, I misplaced his picture. I took a picture with him, but I misplaced it. His name is Abdessalam Vigo. And Abdessalam Vigo, a jurist, professor, wrote over 20 books on Islamic law as well as on other topics. He was one of the individuals who can say, well, this is a conservative individual. When I sat down with him, he talked about how it was almost the jurists of the past, almost, although it is not true, but he said they almost agreed, they almost reached consensus on the requirement of the wali. And a marriage, according to him, without a wali is not a valid marriage. And in terms of the age of marriage, and I would like to quote some of what he said. He said, Islam never assigned a specific age for marriage. Islamic Sharia allowed for girls to marry at as young as 12 if they have reached puberty. Another thing that he said, which he is always suspicious, and others as well, of Western-funded feminist organizations. And continuing on the age of marriage, he stated, while women organizations call for raising the minimum age of marriage, claiming that early marriage harms women, my own illiterate mother married young and gave birth to several children. Through her sacrifice and hard work, all of her children were educated. My mother represents most of the Moroccan women who were married young. What type of harm did early marriage bring to those women like my own mother? The illiterate woman, my mother, who married young and produced several children who went on to become medical doctors and successful individuals, has suffered no harm. My mother suffered nothing due to early marriage. However, women organizations have always exaggerated the claims, fearing that young women may be harmed and may not be able to raise 1 or 2 children. Increasing the minimum age of marriage is not the right answer to solve many of Moroccan society's issues. To him. He went on to say, in many cases, early marriage is the right solution for a Muslim country like ours, where people marry at a young age to avoid vice and immoral issues. He also claimed that delaying marriage is the problem, where men and women who marry late oftentimes fall into immoral acts and commit sins. Straight conservative opinion. He's also a Sufi, by the way. He is also a Sufi. The second one is Fatima Buslema. And Fatima Buslema is a professor at the same university that Ahmed al-Khamlishi, who we'll meet later on. She teaches Islamic family law. A trained jurist, and an individual at the time when I met her, she headed a conference, and there was at least 30 individuals from faculty and staff who were under her authority during the 3-day conference. When I asked her about the age of marriage and whether she agrees with the Mudawana of the marriage of 18, she gave me an answer which had tied the Muslim jurists from the past to the present. And what she said, when early jurists, past jurists, authorized early marriage, they did this according to customs and traditions of the time. Today, we are in need of rulings which reflect our customs and practices of the Moroccan Muslim society. In the 21st century, we need new ijtihad. We need new ijtihad to help produce appropriate laws which are different from the laws that were carved centuries ago. We're in need of jurists who are in touch with our society's needs, since Quran and Sunnah did not elaborate on every single issue in society. However, Buslema is of the opinion that a marriage guardian is required for a woman to conduct her marriage. She stated to me several reasons, and I'll bring some of them. She says that the guardianship brings the woman honor and respect, as the groom and his family will recognize in the wali that the woman has someone to protect and look after her. Second, a new marriage brings with it a new relationship between two families. The objective of the wali's investigation, who usually investigates the groom or the potential husband of the potential groom, is to ensure that the two families are suitable for this new relationship. According to Moroccan Islamic customs, and I learned that when I was there actually, that the father, I forgot about it since living here, that the father has always been the financial supporter for a wife after her divorce. And that it is inconceivable for a woman who was raised and cared for by her father to marry without his permission. So to her, it's a sign of respect to have the father particularly be the marriage guardian. And the guardianship is a matter of custom. It's a matter of protection from falling into the wrong hands. The second individual is a physician by training, Dr. Asma al-Mrabit, and she heads one of the most conservative Islamist organizations in Morocco called Al-Muhammadiyya Party. Her opinions are completely different than the other two. She is for raising the minimum age of marriage to 18. And she told me that she feels a woman today should be independent and should not require a man to conduct her marriage. That she needs no man to do any work for her or on her behalf. She, by the way, she's very popular with the French media. She published a couple of books, but she always travels to France and does interviews on the TV. The third individual is Raja al-Naji, and Raja al-Naji is one of the most intelligent individuals that I've ever seen. Well grounded in Islamic jurisprudence. She's a professor of law at Muhammad VI or Muhammad V College of Law in Rabat. She just authored a book on the permissibility, that is permissible for a Muslim to donate his or her body to science or medicine after death. And she announced in the book that she has made the decision and donated her body for science after her death. One of the things that she's done in 2008, she was actually chosen by the king to deliver the sermon in the month of Ramadan in the king's palace. This was a position always reserved for men to deliver the sermon. And she delivered the sermon, and there was quite a bit of, let's say, personal attack against her, that this was not a Muslim custom or tradition, particularly in Morocco, that a woman does that, especially in the king's presence. And when she did that, when she delivered, she had to sit on the king's throne. And the king and the other Juris, all men Juris, sat on the floor. That's why they call her the woman who sat on the throne and seated the king on the floor. In terms of the marriage guardian, she is for the marriage guardian. And she stated to me that it is our custom. And the NGO's work, Western NGO's work, is an assault on our identity, our Moroccan identity. And this is our society, and we want to have a male guardian according to our customs. But when it came to the minimum age of marriage, she said, I am with the minimum age of marriage and will not go below the minimum age of marriage. And the reason she is stipulating that, she said that this is the least minimum, the least a woman, or the least education that a woman may obtain is the high school, and the high school finishes at the age of 18. Our fourth individual, which is Ahmad al-Khamlishi, and Ahmad al-Khamlishi he was born in 1928. He's 86 years old now. I had at least 3 interviews with him due to the, let's call it, the radical opinions that he had, and the interesting discussion we had between us. He was born within a traditional conservative family. His father was a Sufi, He memorized the Quran at the age of 10. Went on to religious school, obtaining his undergrad and graduate degrees in Islamic Jurisprudence, and obtained a degree in law. He was a judge at first, and then later on taught Islamic family law until he was appointed the head of Dar al-Hadith al-Husayniyya. It's a conservative institution only for graduate students, and it teaches Islamic jurisprudence. Ahmad al-Khamlishi, when I asked him about whether Islamic law or Islamic jurisprudence can be reformed and what rulings can be reformed, and his answer was, any legal transaction, whether Muslim jurists have reached consensus on the issue or not, can be revisited, challenged, and can be reformed. He said in terms of the transactions, they are open. In terms of the consensus of the jurists, of the past jurists, and I'd like to quote him in this, Ahmad al-Khamlishi was critical of the consensus of the past jurists as a source of law. This consensus, according to him, while started in the 8th century, could not be generalized as a source of law to all Muslims living throughout the world in different centuries. Rulings which were the outcome of ijma' may not be considered for Muslims living in Spain or Africa or the Middle East. Even if some of the ulama have agreed on certain rulings, these rulings are considered their own opinions and are open for reforms and changes. The consensus, according to al-Khamlishi, must be restricted by place and time. And what he said, that if we, for example, reach consensus in Morocco, Algeria should not have these consensus as well. They should have their own consensus. But what he said, that the consensus that are understood through Islamic jurisprudence books is a dangerous method to uphold. Why? Because consensus is an authoritarian method to him, founded in order to monopolize fiqh by male jurists, or Islamic jurisprudence by male jurists. Through the method of consensus, jurists aimed at closing the gate to anyone attempting to challenge their authority. That was his opinion. In terms of ijtihad and the method of ijtihad, al-Khamlishi was against individual ijtihad. And instead he advocated a new type of ijtihad. He called it the collective ijtihad, or al-ijtihad al-jama'i, instead of the individual ijtihad. To him, this ijtihad is practiced by men and women who are jurists or professionals, experts in law, science, and by intellectuals who represent civil society. So it's no longer the jurists that may practice ijtihad. Reforming the Mudawwana, according to him, should not be limited to jurists, but should also include other experts in law and social issues. So could a mujtahid be, when I asked him, could a mujtahid be, a woman could be, and he said yes. And actually after that I met with Raja Naji, that we met a few minutes ago, and I asked her if she considers herself a mujtahid, and she said yes. She said yes. So what is the role of a faqih, a jurist now? I asked. That's after observing this in one day. The next day I went back and I asked him, what is the role of a jurist? Because a jurist to us is one who is expert in Islamic jurisprudence and may issue decrees, or a mufti that can issue fatwas, non-binding, but they're still followed. And particularly in the age of marriage, what he said, he asked me, what qualifies a jurist to make a ruling regarding the age of marriage? A jurist's opinion is only his opinion and must not be considered a law. The jurist is nothing but a spiritual advisor, wa'id in Arabic, and he's not a lawmaker. His opinion is one among many, but never a law. Al-Khamlishi's influence went beyond his students. NGOs quoted him, cited him, copied his methodology. And when I visited some of the NGOs, they were happy, of course, to give me their brochures and their books, and I'm looking, and after reading them, I realized that, first of all, they are including Islamic Jurisprudence. This is a French-funded NGO, and you look at it and you see opinions similar to Al-Khamlishi, the methodology, argument for raising the minimum age of marriage, the argument against a marriage guardian, are all there, stipulated just as if I'm reading something from Al-Khamlishi or other books of intellectuals. His influence was profound in Islamic family law or on the Mudawwana. I counted over 22 articles from the Mudawwana, the 2004 Mudawwana, that were actually either inspired or the work of Ahmad al-Khamlishi. His idea or his fight, and he was honored, by the way, for these accomplishments by other intellectuals in 2 universities in Morocco, and for his hard work in reforming the Moroccan Mudawwana. He fought for increasing the minimum age of marriage to 18 for both men and women, almost eliminating requirements of the marriage guardian. Now, prior to the 2004 Mudawwana, a woman does not have to appear in court to be married. The marriage guardian will have her sign the contract at home, for example, and brings it to witnesses. Al-Khamlishi insisted that the woman signs that in presence of the 2 witnesses at court. He fought for the restriction of women's unilateral right to divorce and restricted the polygamy. Now, if a man wants to marry another woman, his current woman has to go to court, sign that she is accepting the new wife, which is, of course, nobody wants to do that anyway. And divorce has to be in court. A man has no authority to do unilateral divorce. The family judge now is assisted by legal experts, no longer has the sole opinion on deciding on the minority, on a minor's marriage. Also, he is provided with help in terms of overseeing divorce cases, alimony, and child support. For the first time, Ahmad al-Khamlishi had to fight, and he told me that the term DNA in English, they fought bitterly over the term, and they had to translate it into Arabic to write it down in the Mudawwana, but they admitted that. They admitted the evidence. Now, if there is a question in paternity, the court may order a DNA test. And also, if anyone breaks any of the articles of the Mudawwana, this individual could be brought to justice and having criminal consequences for that. Undocumented marriages, this is my last thing, and there is a custom in Morocco in remote areas where minors are married verbally, in a verbal ceremony with, this is unique to Morocco, I believe, there has to be 12 witnesses to the marriage. And it's prevalent in remote areas because of the lack of schools, lack of services, poverty, and unemployment. And what Al-Khamlishi proposed, and this actually is happening right now, for these marriages to be given certain time to be documented. But no one may marry after a certain time. The time expired in February, but they had to extend it because of the numbers of marriages that were coming to them. So from this, I hope that I made things clearer in terms of an intellectual like Al-Khamlishi, who had a profound impact on Islamic family law, and also that conservative intellectual Arab Muslims like him, and like Allal al-Fasi as well, were capable of producing liberal work and shifting the discussion over gender rights in Islamic family law. And the last thing that I wanted to emphasize, that it would be difficult to make a dichotomy that we have a liberal intellectual, for example, and a conservative intellectual, because we've seen that conservative, or what we perceive to be conservative, may have different opinions, and not all conservatives have the same type of work. And thank you very much for being here.